suppose logically standing is an antecedent question to mootness, right? You can't have something moot until you have a case.
That's correct, Your Honor. I think that the first question the court should decide in the case is whether there is a case or controversy in the first place. The concept of mootness almost presupposes that at some point it wasn't moot. And we think that this case, there was no case or controversy in this case from day one. That's the question the court granted certiorari.
Right, but we've never done that before, is what I understood your answer to Justice Sotomayor to be. So if it's sort of a logical antecedent, why hasn't this court set it up in that way? It would seem to me the question is, which is the easier resolution? And so to the extent that you both agree that this is moot, why isn't that just the end of it?
Well, Your Honor, in terms of not having done it before, it's very unusual for a plaintiff for a respondent who prevailed in the Court of Appeals to abandon her claim in the Supreme Court. That comes up very rarely. And I don't think I've ever seen a case quite like this one where the seeming purpose of the abandonment of the case is to allow other plaintiffs.
No, I understand that. But when it happens, their cases do get mooted. And when it happens, the defendant's ordinary course of affairs is to argue mootness. Please dismiss the case. It's over. And you're saying that the case is moot. You agree the case is moot. So I guess with at least circling back to Justice Thomas's question, why doesn't that just resolve it? You're asking us to take on extra work to end a case when we've all agreed it has to be ended, and ordinarily that would be all.
I think the court, with apologies, should take on the extra work, Your Honor.
I'm sorry. Well, go ahead.
I think the reason it should decide the standing question in this case is that I think the court should have institutional concerns about the strategy of abandoning cases at the last minute, especially if it's going to set a template for future plaintiffs to do the same
Isn't
thing.
the remedy for that Munsingware, though? I mean, shouldn't your answer be moot the case and vacate the lower court ruling to the extent there is one against us?
I don't think that's good enough, Your Honor, because first of all, the First Circuit's case is still going to be persuasive authority to all district courts in the First Circuit who are going to know that if the case goes back up, then presumably—
But that's what the Munsingware remedy is about, isn't it? I mean, it's so that you don't suffer any harm. We vacate the lower court opinion because if you're right, there's some kind of tactical strategy here, and then we all go home.
Well, remember that Ms. Laufer's victory in the Fourth Circuit remains binding precedent in that court. And I just think this case is different because it's part of a broader litigation program of bringing hundreds and hundreds of lawsuits. That's what I think makes this case unique.
May I follow up on — I'm sorry.
I was just going to say, I'm as concerned as anybody about our workload, but why are you sure that which one's easier? I mean, on the one hand, you have the standing question. Maybe people will think that's easy or maybe not. The mootness question is whether or not a plaintiff can moot a case to manipulate the jurisdiction of this court. I mean, the mootness papers weren't filed until after the petitioner's opening brief. And we certainly have the authority under our precedent to decide if you have two jurisdictional issues, which one to do first. And in terms of, I think it's a difficult question as to whether or not somebody, particularly when you have a program of litigation like this around the country by people who may or may not have standing, can manipulate the court's jurisdiction by, after the court's granted cert, mooting out the case.
I agree with that, Your Honor, and I think that if the court were to write a precedential decision addressing or agreeing with respondents' theory of how this case should be resolved, presumably the court would address our objections as well.
Counsel, in this case, this plaintiff has dropped all her actions. The lawyer who did this strategy has suffered disciplinary proceedings. She's represented she's not going to use him anymore. So, yes, there may have been a bad tactic in place, but you're ascribing a motive to other people before it's happened. And in every other case, I don't think every case suffers from this same set of failings.
I agree 100%, Your Honor. We are not suggesting that all testers or all testers' counsel have acted unethically. The only person who's subject to a sanctions order in this case is Mr. Gillespie, who's the local counsel in the District of Maryland. I think that in other cases with other plaintiffs, I'm not suggesting there's going to be false statements to courts and opposing counsel, but the fundamental program here is to file large numbers of lawsuits and settle almost all of them. Even ethical ADA lawyers do that, and I think the court should be concerned that whether that's permissible will not see the bright lights of appellate review if the court blesses a strategy of banning these cases in the rare situation where the defendant decides to litigate the case all the way up and there's a possibility of adverse precedent.
Mr. Unikowski,